Right. We are back from our recess. We are going to pick up with agenda item number 10, discussion and possible board action regarding the Sunset Review Report.
Thank you. Well, first of all, I'll say we're almost done. And from speaking for staff, I'd like to thank the board for making this a very easy and smooth as possible sunset period. I don't think we could have expected a better outcome. Right now, currently, AB 1706 is the board's sunset bill. It's at Senate Appropriations, and it's what they call in the suspense file, which is really, for all intents and purposes, the least controversial bills. They stack them into a section where they're just going to go through them one by one and call an up or down vote. In this language for PTBC, we will be receiving a repeal of the renewal exemption that's effective January 2019 to allow the board some time to promulgate regulations for retired status. So they'll take that confusion point out, and then we'll be able to rely on 464 of the general provisions. We'll also receive TOEFL exemptions with some discretion. So they'll include those countries that we recommended, but also give the board some discretion to consider other reasons for exemption. They're going to remove the reporting requirement to the legislative bodies about fee increases, which is not something that we asked for, but we're receiving. And also remove the cost of transaction requirement for our fees. So in our fees, we do an assessment of the labor that's involved for the application fee, and that's what we use to establish the application fee. And while we didn't ask for it, they're saying that that's no longer going to be a requirement for this board, that as far as determining application initial licensing fees, they'll leave that to the judgment of the board and the regulatory process. My recommendation at this point would be to draft a letter of support for AB 1706 to the author with the president's signature. And if you have any questions, I'll be happy to answer.
When is the date that our bills set to be authorized or signed? Or?
Currently, the suspense files session is scheduled for September 1st. Oh, you know what I forgot? Forgot the bad news.
Yeah, I see it.
So there is one piece that we requested for consideration of the BMP committee to extend our salary caps, being that we're at the ceiling of all of our caps, or not salary caps, fee caps. We won't be receiving that. However, we have been advised through the Assembly side's BMP and the Senate side BMP that it may be something that they'll consider in the future. They understand the plight.
Any discussion from the board on that agenda item?
When you say you're almost finished, was there an additional response required from the board on any of the questions?
No. We have had conversations with analysts on both sides of the Assembly and the BMP, but nothing that would be brought to the board's attention. The process is taking as long as it normally does. It's not an extension of anything. We have been combined with a couple other boards inside of that bill, but it's, for the most part, business as usual.
I move to have the board draft a letter of support for 1706, maybe 1706.
I'll second.
Okay, motion by Alicia, second by Mr. Watkins. Any further board discussion? Any public comment? All those in favor, roll call vote.
Katerina Elby,
Aye.
Alicia Benamen,
Aye.
Deborah Alviso,
Aye.
Jesus Dominguez. Jesus Dominguez is absent. Daniel Drummer,
Aye.
Tanya McMillian,
Aye.
and TJ Watkins.
Aye.
Thank you.
And that vote was unanimous. Thank you, Brooke. And Jason, you started out by thanking the board for making this easy. Thank the staff, please, for making it easy on us.
I will.
Yeah, it's definitely a two-way street. All right, any,
Additionally, commendation to our council
yes,
for her
definitely.
amazing work in plowing through the process with us.
Aye.
I'd like to second that, yeah. All right, let's move on to agenda item number 11, the legislation report.
Okay, so on page 25 of the agenda materials, just referring to the calendar, September 8th is the last day to amend bills on the floor, and October 15th is the last day that the governor will be signing or vetoing bills that have been passed by the legislature by September 15th. I'll direct members to the legislative summary, and I'll just go ahead and provide a brief update on any bills that have changed since the distribution of the materials. Going right to AB 208, which is on page 29 of the materials. This is the Deferred Entry of Judgment Pretrial Diversion Bill by Eggman. This bill is duplicative of AB 1351 from the previous session that was vetoed by the governor. I did include in the materials letters of opposition that the board sent to both Assemblymember Eggman and the governor. And on 8/21, this bill did move to the Senate Appropriations suspense file. Moving on to,
Sorry, Brooke, just to clarify then, in the table that describes all of the bills, and AB 208 currently, it says no position.
correct, the board has not taken an official position on this bill at this time.
Oh, I'm sorry, I heard you talking about.
Oh, from the previous session, yeah, AB 1351, which is a similar bill, we did take an opposition.
Okay, thank you.
Okay, moving on to the next bill that had a change in status was AB 508 on page 32. And this is the healthcare practitioner student loans bill. On 8/21, this bill was read a third time, it was passed, and it was ordered to the assembly. The next bill that had a status update was, of course, our sunset bill that Jason touched upon on his report. And again, that went into suspense file on 8/21. And those are all of the updates I have at this time.
Thank you, Brooke. Do the members have any comments on the ledge report? Any discussion? All right, now let's move on to agenda item number 12, the rulemaking report.
Okay, all rulemaking items that were adopted from the 2017 rulemaking calendar were included on our rulemaking tracking form. Also included in the rulemaking report was the updated DCA rulemaking process, which reflects the updated process. So I just wanted to have that again in there to remind the board of the extended time period for rulemaking. Going right into the rulemaking tracking form. The first item, which is on page 40, the first item is the satisfactory documentary evidence of degree for licensure as a PT or PTA / coursework tool. The proposed regulatory language was presented to the board at the May 2017 board meeting. PTB staff are currently in the process of revising the proposed language to include the board's feedback from that meeting, and we will be hopefully presenting language at the November meeting. The second item on the rulemaking Tracking form is the examination passing standard, setting the exam score. Proposed regulatory language was presented and approved by the board at the May 2017 meeting, and we are currently working on the rulemaking documents and will be submitting to DCA hopefully very soon for their review. All the other items on the rulemaking tracking form were added to the 2017 rulemaking calendar, and so we're still researching those and putting together proposed language for those items. On a side note, our Section 100 changes that were submitted to OAL in late May were approved, and they went into effect July 6th, 2017. And those are, again, changes without regulatory effect, and they're mostly cleanup and addressing any type of authority citations and that have been revised or repealed. And those are all the updates I have for rulemaking at this time.
Thank you, Brooke. Do the members have any questions about the rulemaking report?
Does that report include PDF pages 44 and 45? Or are we getting to that?
The page 44, oh, the DCA process?
Yeah.
It's the same that was included in previous materials. It's just showing the change where now we'll have to go ahead and submit rulemaking packages to DCA for review before we notice the language with OAL.
And what, I'm trying to understand the difference what the headers mean when it says final phase and initial phase. Like, help me understand what that refers to.
The final phase is what you're used to. The whole second page that they're calling the initial phase is the new section of review, where for a couple different reasons, there's additional oversight review by agency and by the department. And so there's going to be a significant amount of time added to the review process for DCA legal counsel, and then also an opportunity for agency to opine on language before it's even adopted by the board to present as a noticed item. So they've taken what was normally an informal process and made it a little bit more formal, having approvals before it even gets to a publicly noticed regulatory hearing.
So the process that's outlined on final phase, that's what we currently use?
It's very similar to what we've used in the past.
Okay, sure, in the past. And then the next page that's initial phase,
Which is in addition to.
that's what I'm trying to understand.
Yeah, they're out of sequence on the book, so you could look at initial phase first and final phase. So they're putting a lot of review on the front end of the process, which we're calling initial phase, that is review at both the department legal level and agency.
Before the board sees it?
No?
Oh,
But before the board adopts it to notice it to the public.
okay.
I have a question on page 43, the processing times. So DCA is allowed 30 calendar days. Department of Finance is allowed 30 days. Is that calendar or is that working days? Because the OL is allowed 30 working days. Is there a difference? Like
They would be working days.
working days, okay.
And again, the processing times that are referenced on that page are part of the final phase on the next page. We're trying to make it as, or not make it as confusing as possible, but it is rather confusing at this stage.
Any further discussion on agenda item 12A? Hearing none. All right, let's proceed to 12B.
Okay, so for agenda item 12B regarding the regulatory revisions to CCNR 1399.15 for the guidelines, I'll go ahead and defer to Elsa.
Good afternoon.
So, what we have here are the disciplinary guidelines, which is what everybody uses during closed session for our disciplinary actions. And the one that's currently being used was adopted in 2013. So I thought it'd be a good idea to bring it back, just clean it up, and anything new that we want to add, this is the time to do it. So you have a copy of the edits that Jason and I and Tara and Sala have gone through. So I'll wait for your edits, revisions, or comments, and I think we'll just go page by page, make it easy.
So I'd just like to make a note that part of the review of the guidelines package is reviewing the regulation itself that provides for the guidelines, which is included in the package, and the board should review that to make sure that you're on board with the proposed changes for the regulation as well. That starts on page 48 of the binder.
Mhm. So page 48 is the proposed language for 1399.15. Are there any comments? This one is mostly just inserting a current date once it's adopted, and then changing the 5th edition to 6th edition. And then there's a couple of sections that were crossed out in B2, I believe it is.
Reordered.
Yeah. Thank you, Jason.
There's also a couple references to authority and reference added on the second page.
I wasn't there yet.
Well, I bring everyone's attention to that because those are substantive changes that require the board's approval versus the other changes on the first page, which are more minor and technical at this point.
And since you're calling attention to it because it's substantive, can you briefly tell us what 11400.20 is about?
Yeah, Elsa's memo actually does a really good job of including all of the references, but I'm going to refer you to the top of page 47. It provides the language contained in that GovCode section, which is really helpful to the board because it provides the authority to make this type of rulemaking with respect to the APA. That page, the addition of BPC 2660.2 is, I believe, the board's authority to suspend a license. So effectively, that's really just, we're just making sure we've got all the bases covered. Sorry, that one is the board's ability to refuse a license to an applicant guilty of unprofessional conduct or sexual activity, which is referred to in the guidelines, as well as this regulation.
Any comments? No? So for this one, they will need a motion at this time, Tara, or after?
After, because really
Put it all
this
together.
rulemaking, contemplates changes to both the regulation itself as well as the guidelines.
So starting with page 51. We've We've included all of the new board members and then deleted the ones that have stepped out.
I see that we're striking the December 2013 date. Will we be adding
A new
the
date,
new date as well?
once it's
Okay.
adopted. Page 52. That's the table of contents. And I just put a note in there that all of the pages will not be revised until once the document is complete and we know what page everything's going to fall in.
Toward the bottom of the index,
Mhm.
the new language, recommended language for issuance, I think we need to strike of comma. And on the second line, strike the comma after probation. This feels very familiar to the sunset review process.
Apologies.
Since you stated it that way so eloquently, a few of you are familiar with this process from the past. It's a very large regulatory package, and so I don't think the expectation is that we finish deliberating on this package in the next hour or two. It's going to take a little bit longer than that, but if there's anything along the way that you'd like to highlight or comment on or have question about, we'd be happy to address any issues or questions you might have.
Are we gonna go page by page?
I can just say the page number and you tell me to stop. How's that? I don't know
Yeah,
when
there's only
you're...
one problem, which is, because you sent it out ahead of time, I've done my edits in a Word and not in the PDF, not in the agenda materials,
Mhm.
so I'm gonna need help.
Okay.
Trying to figure out how to do that.
So you have your computer with you?
I'm looking at it, but I can't go by page number.
Yeah.
Oh,
You can, because starting on page 54,
Okay.
it'll have the guideline page numbers on there. So on 54, it also has a page number 5.
how about I do that?
Yeah, so we can start,
No?
No, I got it. Yeah, I do. Yeah, I do.
okay.
Okay.
So after the statement of purpose page, which is the one before page 5, then you can start referring to the guideline page.
Yeah.
And we'll all be on the same.
Page.
Wow.
Hopefully. Okay, so right now we're on statement of purpose, intent, and expectations.
So I have one question on that, which is down near the bottom where it says these include.
Mhm.
I think you're still referring to these expectations, because
Mhm.
that's how that paragraph starts.
Right.
But the end of that paragraph kind of talks about the mitigating circumstances must be detailed, and then it says these include. So I was thinking it might help to say the expectations, or something referring to that. Some introduction to that list.
These expectations include? Is that enough of a bridge to the content?
I think maybe keeping in line with the beginning of that prior paragraph, you might want to just say the basic expectations include.
There you go. That would probably do it.
Sorry, basic expectations include or basic expectations are? To be more definitive.
I don't have a preference.
Legally, which one would be the appropriate one, Tara?
I'm trying to figure out if there are more than 5. I think it's probably safer just to say include.
Okay.
Also, in paragraph 2 on that page, first line,
Mhm.
the board is producing this should be these, because we're striking addition, so now it's these guidelines.
Moving to page 5 of the guidelines. That's the second page. Page 6, legal authority.
In conformity with the changes in the proposed regulation, we should add on the added provision, legal authority, second line, starting with sections 315. After 2660.1, insert 2660.2, comma. And after 2661.5, semicolon, add government code, sections 11400.20 and 11425.50, paren E, end paren, semicolon.
I was thinking the same thing.
Stole my line.
Tara beat you to it.
No, Deborah. did.
Deborah.
Also, on the citation to the regulation, section 1399.5 should be .15. In subparagraph B, second line, in the parens commencing with section 11500, there should be a space between section and 11500.
Page 7. Page 8, authority to examine due to mental illness and/or physical impairment.
In bold, under the title, starting with Business and Professions Code, strike the comma. On that same line, strike the underlined space right before examination.
Page 9. Page 10, definition of abuse rehabilitation programs.
Can you go back to page 9?
Mhm.
And at the beginning, the third sentence down, if the, and then there's
Oh.
that blank
Yeah.
space there.
Page 10.
Back on page 9, the line that starts with examination, looks like there's a couple spaces between examination and given.
Page 10.
Under self-referrals, about the fourth line, it says rehabilitation, and that's misspelled.
Rehabilitation.
And then continuing that sentence on, it looks like the word "and" might need to be inserted. The rehabilitation program shall report the facts and shall provide all documents. I wasn't sure, but it looked as though.
I think I struck it by accident. but-
Right. I think that's currently in the language, so the strike through should be removed. So then "and" will remain.
Mhm.
In number one, in reading through parens 2, participants who have been ordered into the board's rehabilitation program as resulting from violations of the PT Practice Act related to drug and/or alcohol addiction. We don't often refer them into the program because of addiction, because we don't know, we refer them to be evaluated for addiction. But they may just have excessive use violation when we refer them. So I'm wondering if related to drug use and/or drug and alcohol use or addiction should be the better content thought process.
For consistency's sake, I see a value of adding the word abuse. So related to drug and/or alcohol abuse or addiction.
I can live with that.
Or I think the Uniform Standards talks about violations involving drug and alcohol use or drug. I don't know that it uses any qualifier of calling it addiction or abuse even.
Correct. It's broad enough to encompass both by saying violations involving the use or abuse of alcohol or controlled substances. And it comes up quite a bit as an issue with respondents that there's a difference between addiction and use or abuse for that matter. I think the general consensus is that if the violation led you to this path, that constitutes the definition of abuse. That social casual use could also be classified as abuse without bordering onto addiction.
May I make a suggestion? The line above it starts off with resulting from violations of the Physical Therapy Practice Act related to, and I think perhaps we could just say drugs and/or alcohol, period, because really what we're talking about are violations of the act, not that there's abuse or addiction, it's that there's been a violation related to drugs or alcohol.
I knew you would do the right thing. Thank you.
Page 11.
On 10, below probationary participants, fourth line down in the title, standards regarding substance, insert hyphen and make it underlined. So going back to our discussion about the violations of the Physical Therapy Practice Act as it relates to drugs and alcohol on page 10 in 1, if you add S to drug, you'll have to underline S.
Where was that again, Tara? I'm sorry.
In what looks like paragraph 1, line 4, starts with violations of the Physical Therapy Practice Act related to drug. Insert S, so it's drugs, and then underline the S, and then strike through addiction.
And this is kind of a global edit. where you can find it, but on page 10, under probationary participants, third line down, it says section 315 with a capital S. I would say that where section follows the name of the code, it should be a lowercase s. Where section precedes the name of the code, for example, had you left section 315 of the business profession code, that's when S would be capitalized. So I would do a global edit to kind of make it fit that pattern.
Page 11.
Just curious on the monthly administrative fee, would it be, is there any way to, where it says the monthly administrative fee is currently $358, could we just add a date to that? Like as of August, I don't know if this is appropriate, but if someone was looking at this in a year and a half, that they would know, actually this refers to August of 2017 or something like that. Because it seems like you're just giving a reference idea of what, or do we need even a number in there?
Right.
Would at the time of publication make that clarity? At the
Yeah, I
time
think
of this
it would. And somebody,
publication?
if they really want to know, they could look that.
Just look right on the front.
Or in parentheses, put or current fee.
But current would make me,
Wouldn't tell you much.
Are we just including the number just as a courtesy?
Trying to give them an idea of what the costs of the program involve.
So at the beginning of that sentence, we're going to insert at the time of publication, comma, lowercase t, the. And at the time of publication, comma, all needs to be underlined.
And we're going to repeat that under random biological testing as well for those prices.
Yeah, I think to be consistent,
As well as professional support group meeting fees.
Wherever there's a fee.
Oh, well, that's a range, so,
but it's still at this time.
okay.
So,
Under monthly administrative fee, there's a double or triple space, and the rest are single, so I would just make it single to match.
Where's there a triple one?
Monthly administrative fee, colon.
Okay. Page 12.
At the top of page 12, you need a space after the very first line. Add a line.
oh, like between the paragraphs.
Yeah.
Mhm.
Under clinical assessment, second line and the sentence starts, there is. Preceding that, looks like there are three or four spaces. Looks like the rest is two, so I would just stick with that.
think some of the spacing issues that you'll find is a conversion between Word and PDF, so but we'll be searching for that on a global scale.
Page 13, denial of license and issuance of an initial probationary license.
In the line above the bullets, middle of the page, it says to the following, add a comma after to, underline.
Page 14.
Second paragraph, second line from the bottom, beginning with license to any applicant. I think we need to delete for a license. So it'll read, license to any applicant who is guilty of unprofessional conduct. Then in the first paragraph below appeal rights, third line down, after chapter 5, delete comma.
Page 15. Public approvals and reprimands.
I had a couple of questions on this section. My first one was the lead into that where it says any of the following circumstances. And it either needs to either still say exist or under the following circumstances. I wasn't sure, but there's something about that sentence that doesn't lead into the list. But then I got a little further down and I wasn't sure if on number 5, if the and means that it has to have all of those things. So then I actually just needed information.
I'm wondering if the exist that's underlined was inadvertently struck out, because that the underline there replaces what was struck afterwards.
Yeah, it does have both.
So I think that if any of the following circumstances exist, that seems to have been reinserted there, because it was deleted afterwards with the revision of the closing phrase.
But then with the word and, then I'm actually questioning, does it mean any, or does it mean,
Or,
or does it mean all 5, or all 6?
I think if any of the following circumstances exist was actually supposed to be in any of the following circumstances, colon.
If,
So if should be changed to in, in.
any of the following circumstances. So then do we need and down there? Or are those all single? And number 5, where it ends with and? it says.
From what I can tell, this list is really just more of guidance to this board, because 495, this provision is an interpretation of the actual code section, which is smaller than what is provided in the guidelines. So this list is for the benefit of the board.
So removing "and" doesn't change the meaning of that list in any way.
No, but I think if you remove "and," you'll need to remove all the semicolons and just have periods at the end, effectively returning it to the way it is currently, except for the revisions in the prior sentence below the list, or I mean above the list.
So the construct of the old language is that the board could consider issuing public approval if all 6 conditions are met. Correct? The board may consider, looking at the language that's been struck, the board may consider these things when the following circumstances exist. So all 6 of those items must have been met. So that's where the "and" would be appropriate. But if the new language that's proposed, if any of the following circumstances exist, it would seem to be that only one of those items might be necessary, and not all 6 of them necessary in order for the board to consider approval.
If is now in.
Well, with that, that's a good point, because I think actually "in" should not be "in," it should be "if,"
Should be.
but "any" should be "all."
I see.
So if all of the following circumstances,
So that was what I'm trying to think.
Exist.
What's the intent? Is it
Right.
all? It is all?
I think it is all, because
It was all, looking at the old language.
right, so I think "any" was probably what was screwing us up. So, the board may consider issuing a public approval as part of a disciplinary order if all of the following circumstances exist. So,
Then "and" could stay.
right. So, for purposes of OAL review, we need to completely delete "exist" as it is underlined and stricken. So just, take it out there, and then at the end of that sentence before the colon, don't have a strike through "that exist."
Okay.
Are we leaving the word "any" in there?
No, "any" is turning to "all."
Okay, good.
Good work, team.
So it begins.
In number 1 on that page, first DUI, on that second line, egregious, strikes through a space. So remove the strike through from the space before the paren.
There's a period in there, or is that,
Strike through the period, not the space.
okay, gotcha.
And number 3 of that section, I was wondering if, where it says failure to maintain records such as an isolated incident of documentation violation, I was wondering if it should say, if there should be any qualifier to that, if it needs it, without significant consequence, or if that's understood that you're looking at something that was innocuous in the terms of any patient harm. Because it could be isolated but terrible.
Oh, yeah.
Yeah, so I was just trying to, I didn't know if it was necessary here.
Jason, this might be your bailiwick here. When issuing a public letter of reprimand, what goes into your consideration? And I'm not sure if you've issued a reprimand in this type of circumstance, but what would you be looking at? What kind of minor violation would this fall under? Or how could we describe a minor violation in this context?
I have, and I'm sitting here contemplating the clarity that Dr. Alviso is trying to attain, and I agree with the idea. I'm just unsure on how to get there. As a descriptor, we're saying an isolated incident, but to Dr. Drummer's point, an isolated incident documentation can still lead to a very egregious violation. I think for a descriptor's sake, for potential respondents who would be reading this, I think the clarity is still there. I don't know if I'd want to narrow the window any more than it already is.
Well, I'm wondering if we should even include 3, because there are various types of violations for failure to maintain a patient record, and it's difficult to figure out which kinds are minor, and this example is not a good one.
We did include it originally as these were 3 of the most common types of violations that a public reprimand is issued for. And so, I mean, we do say includes but is not limited to the following. And the following was just to give the reader that transparency that, we would expect to give them so they have an idea of what to look forward to should they violate. And that third one is one of the most common ones, is documentation issues that are higher than a level of citation, but not quite at the level of discipline because it didn't lead to a negative outcome for a consumer.
Would it be better to just remove the example and just keep it with failure to maintain patient records? That way it's more broad.
I'm comfortable with that.
You said you are comfortable?
I am.
Okay. What does the board think?
I'm comfortable with that too.
I'm thinking maybe it could say something like certain incidents of failure to maintain patient records. Otherwise, it sounds like you're minimizing patient records.
Right. I'm wondering if maybe restructuring the sentence to say examples of minor violations may include or might include. Because it to me, it flips the need for the severity. where it says that minor violations include these, and instead, examples of might be this. To me, it just frames it differently.
So it would be we could do minor violations, strike the comma, may, insert may before include colon, and then strike but are not limited to the following. So then the emphasis is on
May.
right, that these are minor and they may include these three. And then, did you want to keep such as an isolated incident?
I worry that without a qualifier there, that failure to maintain patient records is going to stand alone. And that's a bigger deal than just a single violation or a simple violation that didn't result in an injury or some other adverse event.
Could it be edited to say failure to maintain patient records such as an isolated incident that did not result in consumer harm?
I think the tricky part is putting records in here as I'm thinking that it almost creates the thought that
Yeah.
so often what we're looking at is the patient record. That's our record that we have. Oh, well, it's only a public letter if I don't maintain them, so.
What about minor documentation violations? Because I agree with you, the part that makes me uncomfortable is the use of the word patient records.
Yeah, documentation is a little more broad.
And contemplates one entry versus the entire record.
And I think your point is, you're just trying to show that an example would be these, but it'd be taken in total of all the circumstances.
Absolutely.
And that might be what needs to be explained, that these are only minor based on everything else that's behind the story.
But in the phrase minor documentation violations, we're prefacing it, we're pointing it out that it's minor.
I like minor documentation violation
Yep.
as than anything else.
Is there consensus on that change as an edit? So striking all of 3 and replacing it with minor documentation violations?
What about striking failure to maintain patient records such as an isolated incident of A, and then just include the word minor before documentation violation?
I think is that what you were talking about, Jason?
I was before, but I think backing away from it even further with just the 3-word phrase of just minor documentation and violations gets away from that confusion that might be created with patient records.
Yep.
Oh, I thought she was talking about striking it off.
Yeah.
I think you guys are saying the same thing.
Oh, okay.
She's just talking about how to do it.
So
Are
we're
we-
striking 3 completely.
No, we're striking failure to maintain patient records such as an isolated incident of A,
Okay.
and then adding minor.
Okay.
And are we adding may include up at the sentence to be an indicator, like Dr. Drummer asked?
I don't know if it has the same effect now with this change,
Okay.
and I would hate to lose the but not limited to.
I see.
Okay. But we do want to make on number 3 violations plural, right? You want to add an S?
Yes.
Yeah.
Could it read minor violations may include but is not limited to the following? Do we have to lose, but it, changing R to is, do we have to lose that phrase just by adding the word may?
No. Minor violations may include, but is not limited to the following. Yeah.
Does is correspond with violations in the plural?
No.
I mean, we could change it to a minor violation, may include, because each one of those is a separate, each 1, 2, and 3 are separate single events.
Well, and that's as far as to the extent that I was comfortable with. So
Yeah.
there are situations where I still find this to be appropriate, and there are multiple minor documentation violations. Because of the sheer nature of documentation, those violations might be recorded once and recorded, in several different places, but really it's a single offense. So the plural in S, for me, is a clearer description.
But the issue that the board is issuing a reprimand is a collective. So it would be one violation that we're citing, that we're reprimanding them for, but it may include, I understand, there may be a couple of different places where documentation may have some minor issues. But as a whole, it's the overall ability of the provider to not document appropriately. So I would see documentation as a more global thing as opposed to each specific incident of a documentation item that you're citing.
Yeah. And because sitting on the opposite side of that and the burden of proof, I'm in my issuance of this letter, I'm going to cite each and every violation as part of it. So.
But the documentation as the global piece is what the therapist needs to do.
Jason, I think your point was to have the ability to issue a letter for multiple minor violations, which I think is provided for in the prior sentence. And then in the sentence that we're struggling with, merely defines what a minor violation might be, what it looks
Fair.
like. So it looks like you still have the ability to issue the letter for multiple violations.
I see my plural above.
Yeah. So perhaps we could then in that second sentence start with a minor violation may include but is not limited to. And I don't know that the following works, because the following seems to go more with a plural use of violations.
Could it be examples of minor violations include? Because really what you're trying to do is just kind of give an example. You're not trying to say these are the 3 things.
And if you use examples, I don't think you have to say but are not limited to, or the following.
I guess the concern I have is just setting an expectation that I'm tied to the examples without discretion outside of them. And so an act or offense that is similar in nature to a single DUI, because it's not listed in the examples, it wouldn't be clear that that would be an option.
I think if you use the term may include, though, that gives you enough room.
Yeah, the may and the are not limited to are somewhat synonymous. I guess I'm just struggling with which one's clearer.
Perhaps examples of minor violations include.
And it's just an example.
Yeah, then it's just 3 examples.
I'm good.
I'm comfortable.
Good.
With which one?
Examples, what was it? Go ahead, Carol.
So, the last sentence,
Got that part.
before minor, insert capital E examples of lowercase m minor violations. Do you have a comma right there?
After,
Violations.
There is one.
yes, there is.
Okay, so strike the comma. Keep include. Insert colon. Strike the rest of that line and the following line. So then it goes right into the list.
Did we miss me?
No.
No, because we replaced it with the word examples.
Right. So it reads, examples of minor violations include colon.
Okay. Page 17?
Do we need to take a small break? How you guys feeling? Okay. Let's take 5. We'll be back around
It's only page
12:50 p.m.
17.
Now after bio break.
17.
Yeah.
Did you start to overflow on you?
Yeah, it did overflow.
Why is your coffee working?
What did Deb tell you?
All right, just a second to get our composure.
Lights, camera.
Any public comment?
We are back from recess. The time is 3 p.m. We're going to pick up on page number, I believe it's 17.
17.
Second line down, end of the sentence, add a comma after paren. And underline.
Page 18.
For all 3 of the code sections referenced on this page, insert a space after the section symbol.
They're all going to be like that then.
No, they're not. I checked. These 3
these right,
aren't.
yes. Okay, you're right.
Yeah.
Sorry.
Actually, there's 5 that aren't, 2 on the next page, but then the ones following.
And that'll be, again, I thought I caught them all, so I'll just go through the whole document and delete that space.
I think it's, no, you'll add the space. Whichever, be consistent. It's these 3 and the next 2 on the following page. I think those are the only ones that are inconsistent with the rest.
Okay.
for consistency then, in the rectangle box under 136, so the second rectangle box from the bottom, there would need to be a space after the symbol there as well.
I'll do a global on those as well. For all. $19.
I have a question near the bottom where it's 490.5, and the lead-in to that says, in addition to the mandatory suspension requirements. I'm not really sure what that means, but would that mean that the discipline minimum or maximum would be suspension? I wasn't sure what that even referred to.
The compliance, 490.5, those are orders that are through the department. So when there's a child support issue, it's the child,
It's family support, failure to pay child support and that kind of thing can result in suspension that is even outside of this board's control. So similar to the suspension of a driver's license for a failure to pay fines or something like that, when a licensee has a family support order and doesn't comply with it, that court can actually suspend the license here. It's within their authority.
So the mandatory suspension isn't done by us.
Correct. Well, so what we're saying here is, in addition to that minimum suspension as set by the family courts, we may also, given a certain set of circumstances, extend it for a longer time or with other conditions, or consider it a violation of the PT Practice Act under professional conduct.
So is the minimum suspension then?
It is when it's imposed by the family court.
But it's not for us. That's what I'm trying to understand. For our for our guidelines, does it stay as the public approval? Now that I understand who's doing the suspending.
We've used it as a minimum by default, saying that we are just in agreement with the sister court, essentially. So whatever they're using, we would use as well. And then in certain circumstances, we might extend it further.
Got it. I can see that it could stay then, because that's happening somewhere else.
Yeah.
That suspension's happening somewhere else.
Well,
the suspension is happening on the license, but then in addition to that, we may go ahead and issue a citation or take discipline.
So the actual section says, a board may suspend a license pursuant to section 17520 of the Family Code if a licensee is not in compliance with a child support order or judgment. I'm reading that because this is authority, not a mandatory suspension. So it seems that the text, in addition to the mandatory suspension requirements of this code section, that's potentially inaccurate because the board may suspend, it doesn't have to. Unless you're saying, in addition to the suspension requirements of the Family Code. Or to make it easy on ourselves so that it's just all about the Business and Professions Code, it could say, in addition to the suspension authority under this section, because referencing the same code section under the section it's talking about is confusing.
So the first part, Tara, that you just read, referencing 17 something, allows for suspension?
Well, I would want to read 17.520 because I don't know what 17.520 says. I don't know if it says a licensing board can suspend for failure to pay child support. I'm assuming that's what it says, because that would make sense then here. A board may suspend a license pursuant to 17.520.
I'm sorry, I'm not seeing where where 17.520 is coming from, that citation, because I'm
Are
looking
you
at
reading
490,
490?
490.5.
That's
Yes,
490.
this is 490.5, which is the section we're talking about. Only it's confusing because on page 19, we're talking about B&P Code 490.5.
Right.
Below that is the sentence that says, in addition to the mandatory suspension requirements of B&P Code 490.5,
Right.
that's the section we're talking about. It's not mandatory under 490.5. It's permissive.
Thank you for clarifying that.
So perhaps it's in addition to the, well, it's not a suspension requirement either. So
The-
it's authority, suspension authority provided under this code section.
I think the disconnect is in the reference of 490.5 is kind of a pass-through to the health, or to the family support code. In that 17.520, it speaks to the two-stage process where they're issued a warning. The board is then notified on a list, and if one of our licensees on that list were to immediately suspend. So the authority to suspend is actually out of the family support for that. But for us, it's mapped back to Business and Professions Code 490.5. So the reference is correct, but it doesn't tell the whole story.
So then, if family court does not suspend, because they choose not, they choose not to, it's not mandatory for family court to suspend.
I believe it actually is. So they're offered an opportunity to come into compliance, and then once that opportunity of compliance is expired, the suspension is automatic. They're put on a list, that list is transmitted to DCA, and DCA, through operation of the system, indicates that license is suspended, and we receive a notice at that time.
And my question is really about the discipline that's listed, and because it's public reproval for both minimum and maximum. And if somebody's license is being suspended, even though it's being suspended by family court, that the only thing that this board has the ability to do is say,
That's a good point.
shake your finger and say naughty.
Well, either or. So should it be determined that it rises to the level of discipline, those are the only options you have. So you have a choice to act or not to act, but you are limited by the guidelines. And then just that caveat of keeping in mind that they're guidelines. There may be other aggravating factors that might lead us to stray from the guidelines, and we would just have to demonstrate what those are. There might be another violation coupled with it. But by itself, the potential minimum and maximums listed right now are public approval. It is up to the board to determine if that's appropriate. It does not happen very often. So it just depends on how strongly you feel about the idea of failing your child support order.
So maybe we could instead strike this provision and just say, in addition to potential suspension pursuant to Family Code 17.520. Because that actually tracks 490.5, the section we're talking about.
Say it again, Tara, in addition to the potential.
So in addition to strike the mandatory, after suspension add pursuant to Family Code section 17520, colon, and then strike requirements of B&P Code section 490.5, period. So it'll read, in addition to suspension pursuant to Family Code Section 17520, colon.
Are we not adding potential?
Up to you guys. It's, again, it's permissive, so but how does it operate in practice?
In practice, it wouldn't be potential. We wouldn't know about it until they were suspended.
I see.
So they're already
They're
suspended?
already suspended.
So it's not potential. Okay.
Systematically, the family courts actually have that access to the system to create that suspension. We would only be aware of it after we receive notification of that suspension. And in some rare instances, we have an idea that it's coming because we also receive the notification of compliance 180 days before. But that's not very consistent. Sometimes it happens, sometimes it doesn't. But I think this is the time where it's appropriate that I give you that pep talk where I tell you how you guys are doing a great job, but we're only on page 19. So let's delve into the really meaty part.
Page 20. Page 21.
And I'll just say that I've noticed through the document that after days and years, that sometimes there were apostrophes and sometimes there weren't. It looks like they're being struck, but just for consistency, whatever is the right one. I think I saw it both ways.
Okay,
With
it should be
without.
the S apostrophe.
Should be without, is that what you just said?
No, with,
With.
after the S.
Okay, I think there's some without,
Okay,
so
I'll make sure.
I won't say it again.
22. 23. 24. I hear an
I had a note to myself. Does,
page 24.
yeah, sorry, let me see. Page 24, right at the top there where there's the conditions of probation, I just had a note to myself to ask, does the condition specific to violation, does this include third-party billing, or is that a standard term? I couldn't remember when I was looking at this. Is third-party billing a standard term?
No.
Let me look.
I need 2 iPads.
It's in the back. I don't think it's standard, because that's more of a specific to violation.
I think
Yeah,
right now
that's-
it's
That's specific to
condition
violation.
F.
Yeah.
And what about ownership?
Ownership, is specific.
That's specific also?
Yes.
And are both of those included on that one?
F. F is the billing, and the ownership is E. So yes.
Thank you.
Also remind me what J, K, and L are.
Those are the prohibition of
Temp
supervision.
services, home health.
J is the supervision of licensed applicants. K is the assistants, and then L is the aides.
I forgot to make a note on prior pages, but this is just a global note to yourself to go through and double check all references of the conditions, because we're adding some and deleting others. So the letters are going to change.
Oh, yeah,
Mhm.
they will.
So in the case of insurance fraud, the comment from staff is whether or not the board would want to add the supervisory restrictions on PTLA assistants and aides as a potential violation or a probation-specific violation or condition to that violation. We haven't had it normally, but because it's an ethical violation, we were wondering if it should be added.
I'd be for that. Turn mine off.
Not that, you know, just like with that caveat that I mentioned earlier, that these are guidelines, but there have been cases in the past where I felt that restriction of supervision should be used in some way, shape, or form with that particular violation, and I might have even entered into some of those in stipulation, with having to explain why I'm straying from the guidelines, but so just from experience's sake, whether or not the board would consider, you know, issuing it as part of the guideline for more transparency's sake to the respondents.
Doesn't seem like anybody's opposed.
So, okay, I'm gonna say yes. Add. Okay, so moving on to page 25.
I have a comment on 24, and this is, so for where it says BP code section 2068-2660A, and then it has both an underline and a strike through for the one and the dot. So I'm not, you'd have to check what's in the original, but we'd want to keep a dot there.
The one should not, it shouldn't have an underline for the footnote.
Yeah, and then this will be kind of a global, but for 26, where there are more than one statute, like 2068, 2660, it should be a double.
The double section.
Mhm. And then this is going to be a global too, but on some of the boxes, like page 19, where it says refer to related statutes and regulations, sometimes it's italicized, sometimes it's not italicized, so I would just keep it consistent to be, it looks like for the most part they're italicized, so I just go with that.
Probably because I was copying and pasting.
Yeah.
But I'll clean this up.
Yeah, and another global edit would be, like, for example, on page 18, if it has statutes and regulations, instead of saying and or, you know, statutes and or regulations, it should say statutes and regulations. That's just a global, which you might see here and there.
Okay. $25. So if I have notes on the side, if you don't have any comments, so I'm gonna assume you're agreeing with it? To go ahead and add in whatever.
That's a different way. Now hold it.
Then you have to
I was
stop
sitting
me.
back for a second.
You have to stop me, because I do have some recommendations in there for consideration to either add or delete. So You need to let me know if you don't agree, or I'll continue on.
But what would be is you have something that maybe you've added and then you have an explanation to it?
I tried to. In most cases I did, or I'm asking for consideration, do you want to add this?
Okay.
So if you don't agree with it, please stop me. 26. '27. 28.
Elsa? So for the last 3 pages, the majority of the context on the right-hand side really falls under the idea of removing the medical statutes that we've been using, that we now have statutes within our own practice act. So there's a couple there that we know we can get rid of because we have a very similar statute within the practice act, and there's a couple there that we're suggesting that we keep because there's still the bridge to the medical practice act, but we also want to, incompetence is a good example. There's no definition of incompetence in our practice act, but we use it once in a while as a bridge from the medical practice act. So I just wanted to give that to the board as kind of an explanation going through those. The weight of them is just really trying to be less dependent on the medical practice act.
So near the bottom of 28, where it's 2289, and then your comment on that, I'm asking Tara, so this talks about the practice of medicine or podiatric medicine. Is this gonna be one of those not really applicable?
I'm looking up 2289 to see if it specifically refers to conduct by a physician and surgeon or podiatric physician. Because I think that's where we got hung up last time, which was the Medical Practice Act had a provision that only applied to a physician and surgeon.
I don't believe that to be the case here because it's impersonation of. But in those instances where a physical therapist is straying outside of their scope of practice and into the Medical Practice Act, and also through the use of the title doctor, purporting to be a physician or surgeon or podiatric physician, we've used that charge.
Okay, so I have an answer. Business and Professions Code, Section 2289, provides that the impersonation of another licensed practitioner or permitting or allowing another person to use his or her certificate to engage in the practice of medicine or podiatric medicine constitutes unprofessional conduct. Initially, I was thinking, well, it starts off with another licensed practitioner, so to the extent someone was using a PT's license to impersonate that PT, that person could run afoul of the Medical Practice Act. However, it would have to be to engage in the practice of medicine or podiatric medicine. So
It could be a PT impersonating, right?
a PT impersonating a doctor?
We have had them.
Really? Okay.
Impersonation of another.
Using the title doctor.
For false impression.
Yeah.
I'm struggling a little bit with trying to understand how an individual impersonating a physician should be dealt with under the Medical Board Practice Act. And so I'm having trouble with why would we be addressing somebody, a physical therapist, impersonating a physician? And if that's the case, that we have that authority, then why do we not have authority to pursue a licensee who is impersonating anybody else? A nurse or an OT or a speech pathologist holding themselves out to be any other thing that they're not. Why is only medicine called out?
But usually in this, for instance, in this scenario, it's not just that violation. There's other violations of the PT Practice Act that were also taken into consideration.
Well, typically what I've seen is it's a charge of unprofessional conduct under the Physical Therapy Practice Act because of a violation under the Medical Practice Act.
And I can appreciate that, but why is it that only the Medical Practice Act is an example? Why isn't why do we not also look at somebody who's impersonating, could be alleged to be impersonating a vet because they're providing animal rehab, or somebody who is drawing blood and so is impersonating a phlebotomist or a nurse? Why is it just the Medical Practice Act?
I would
that's
say
cited?
it's probably because PT came out from under the medical board, and in doing so, there's a provision under the PT Practice Act that allows this board to touch back on the Medical Practice Act to the extent the PT Practice Act doesn't provide for a violation of that. Unfortunately, there are some statutes under the Medical Practice Act that just don't apply well in PT or PTA circumstances. So I think most likely what should happen is a review of the PT Practice Act for situations like this, where when you try to put it into practice, it doesn't apply very well because the practice of medicine is defined, and it doesn't involve veterinary medicine or another PT. So you're right. I mean, why? I think it's probably because it hasn't been fished out properly or fleshed out, and the board probably could stand to take another look at its act to see if there are better ways to specifically provide for those things that are sitting in the Medical Practice Act that should be under the PT Act.
So an agenda item for sunset review 2022?
In an effort to work with the language that we have before us, the impersonation of another licensed practitioner, how broad is another licensed practitioner?
It's not about the licensed practitioner as much as it is about the practice of medicine. So it starts off with impersonation of another licensed practitioner, or permitting or allowing another person to use his or her certificate to engage in the practice of medicine or podiatric medicine. So it's the final conduct itself that doesn't translate well under the PT Act.
Moving on.
On the bottom of that page, I would just switch the section code with the word code, so BP code section.
$29.
Your first highlighted area there is missing the section symbol where it says BP code 2660, parens U.
I think that's just because it's being stricken. She's making global changes to insert the section
I see.
in other areas.
30. $31. $32. $33. $34. $35.
On 34, BP 2639.1, should add code section.
$35.
I have a question on the first code that appears there, BNP 2648.7,
Mm-hmm.
and your comment is that it may be repealed. Would this whole section, would this whole thing go away then?
Yes.
Okay.
36.
Before we move away from that, yes and no.
Okay.
So while it's being repealed with an effective date of January 1st, 2019, we'll then be able to rely upon the general provision of 464 after promulgation regulations. So we'll have to revisit this issue when it comes to the guidelines in the next edition.
One way to do it is if 1706 is signed, and I think it will be before the next time this is brought back, you could just write in the effective dates. So until January 1, 2019, 2648.7, I think that's right, is effective. And then after 1/1/2019, 464 is effective. That way you've got them both in there and you're covered.
Thank you, Tara.
36. 37. 38. 39. 40. 41.
41 at the bottom. I don't know if this is a title that it has to stay that way, but I think, is that adverse?
Yes. Spelling.
But sometimes it's misspelled and we have to keep it that way. Right?
Yeah, if it's a direct quote.
$42.
So it stays adversary?
Elsa's gonna research.
Adverse.
At the top of page 42, inappropriate, it's misspelled. Must it stay that way?
No. This misspell check wasn't working. I will check with how it's written in the current one.
Are you talking about 2660?
Yes.
That is the board's own title for this subdivision, so we can change it, and we should.
43. $44.
On 42, sorry.
Go
B-
backwards.
Yeah. BP code section 2660, there it says, and then you go engaging in acts in violation of BP code sections, and then the word or there, just lowercase it. Well, actually, never mind, the rest of it is uppercase, so I guess you leave it.
$44. 45. 46. 47.
On B and P code, section 17500, in the box, second line, delete 2660, so that it's coming from the prior line 2660 subdivision B, comma, subdivision D.
Back on page 45, issuance of probationary, is that license applicants?
Page 45. What section number is it?
2660.2.
2660.2.
That should be license applicants?
Yes. Thank you. $49.
Sorry, Elsa, back on 47. I'm trying to see if I have something out of context. When, down near the bottom where it says violation of probation, is this referring to in general?
Yes.
And so, it says implementation of the original or stayed order, but the note says, talks about repeated offenses or for, so it makes it sound like there's a minimum and a maximum. What's the minimum end of a violation of probation?
I don't think there is a minimum or maximum. Violation of probation means
Anything.
So,
the original order.
But
Right.
Have we had people that have had a drug test that they didn't get revoked?
So,
And I don't have a specific example, but I'm thinking that may happen.
in those instances,
That's
is
a
it
violation.
is another accusation filed?
absolutely. And so that's the issue, is that you're bringing that second offense before an administrative law judge, and this is providing guidance to him to say that the maximum penalty should be given for repeated similar offenses. And in the example that Dr. Alviso gives is probably the most common violation of an order that we've seen, is that, failing bodily fluid testing or something like that. So while we're saying that implementation of the original state order, which is almost always revocation, should be used, there is due process involved. And so we file an accusation based on the violation itself, and the respondent has that due process with an administrative law judge. We would hope that he would then take that into consideration and impose the maximum penalty. Maybe that sentence could be restructured to make that directive clearer.
I think what might be a little difficult is that there are several audiences for this document, and that particular note is directed for an ALJ.
So I'm wondering why there's even the note of the maximum penalty if if you're talking about, or if you're saying it could even be beyond what the original state order was, based on, depending on.
Well, so the original state order essentially is always revocation stayed, and an issuance of a probationary license. Once they violate that probation, it's not an automatic revocation, if you will. And we've seen from experience that administrative law judges will take that second accusation filed as an offense to the disciplinary order and issue another probationary license with maybe conditions to address, that violation of the probationary order itself, but not affirm that this was their third opportunity. So there is a potential, I guess is my point, that an ALJ would come back with another probationary order.
But we cannot write that little boxed statement and address it to, note to ALJ or what have you. We
Mhm.
can't, can we?
I don't know that that's advisable.
Yeah.
I think that they look at this stuff, but it's also for you guys because you're the ones reviewing the proposed decisions coming from the ALJ.
Mhm.
So
That's true.
it's not just the ALJ.
And it's for the respondent too.
So to me,
Mm-hmm.
a minimum, if we were gonna say such a thing, might be that if this person appears to still be a candidate for probation, that additional terms as needed to ensure public protection be considered, or that and then the maximum is implementation of this previously ordered. I see the simplicity of what you're putting here, but then I would just take out the note. Or, I don't know, or accept that there is both things that could happen.
Hmm.
Would it make a difference to restructure that sentence to begin with the words "for repeated similar offenses"? The maximum penalty should be given, or would that not make a difference?
I think it's
It's the
6
same
of
either
one
way,
and
yeah.
half a dozen of it, but I'm actually kind of contemplating Dr. Alviso's comment about striking the note.
Mhm.
That what more affirmed message can you send to the ALJ that should somebody violate a disciplinary order handed out by this board,
That
That
goes
the
to a level of an
implementation-
accusation.
that the implementation of the original state order should be pursued.
Mm-hmm. Mm-hmm.
You'll agree to delete it?
Any objections? Let's take it out.
48? I think we did.
I think the font for patient record documentation requirement is slightly larger than the rest on the page.
Yes. 49? $50?
CCR section 1399.23 in the middle of the page, in the box.
Mhm.
2660.2 needs to be moved after 2660.1 and underlined. And then also delete 2608.
$51?
I believe. Nope, sorry. I believe the last line there, corporate activates, should that say activities?
50?
51.
50, so mine's 50.
What if he wants that to be?
They can't.
1399.35
Mhm.
in the box. Add an additional section symbol. Change 2691 to be 2690, comma, 2694. 1399.37.
Mhm.
Add an additional section symbol. Wait, strike that. Strike 2691 and add 2696. That's the same revision for 1399.39. Strike 2691 and add 2696. For the second, third, and fourth cited CCRs, I'm making a note to strike "and related regulations" and move them to fall after statute. So actually, it's just refer to related statute and regulations for appropriate penalties, colon.
$53. $54. $55. So we're going now into the probation conditions.
Sorry, on page 53, record keeping is one word. The second section
I'm sorry, record keeping what?
is one word. It's not two words. Oh, not, oh, no, it's one.
55.
Elsa, I had a question on the health and safety code. I don't know what page number it's on, because I think we're a little bit different.
54?
To me, it's the top of 55,
All right, okay.
but the health and safety code, there was a comment about,
Inconsistent.
from Jason, yeah.
Yeah,
What did
thank
you
you.
guys do with that?
So I'm wondering what the board might opine from that. So patients' access to healthcare records violation, the minimum is revocation, revocation stayed, and 3 years probation. In similar codes throughout the guidelines, the minimum isn't necessarily a probationary order. And so it just seemed inconsistent to me to not offer it for this particular violation. And so would we consider lowering the minimum down to that of a public approval? Just broadening the range a little bit.
I'm kind of curious how it got there. I'm wondering what the history was to.
I don't know. That is a remnant left over from deliberations before my time.
What is this violation?
I think it comes into play with Medi-Cal violations that the board's made aware of. And denying patients access to their own records. And so that when it goes to the Department of Health as a complaint first, and then the Department of Health has reached out to the PT board to let us know that it involves one of our licensees, and we use it as a violation. We've said in those circumstances that that's, you know, based on the guidelines, a minimum of probation. And that may be purposeful, it might be intentful. If it rose to that level that, you know, it made it to us through the Department of Health, through Medi-Cal, Is that inferring that it's a more sensitive population? I don't know. So the question is just considering whether or not, is it inconsistent? Should it be revocation, or should it be public approval through revocation?
So a physical therapist denied a patient access to their medical record?
Potentially.
And this is not specific to PT.
That particular violation could occur with a number of different healthcare practitioners, that's correct.
But the reference is to health and safety code.
Correct.
Which
So
is
it would be coupled with another Practice Act violation.
Right.
Going back to page 53, I double-checked the title. 1399.97, record keeping, it is unfortunately 2 words.
Oh, it is, it is.
But this would not, if you were doing an accusation based on a patient being denied, this wouldn't be the code you would cite.
I would use it as what we call a stacking violation. I would use it.
You would.
I mean, I would use it in conjunction with an unprofessional conduct violation, but to specify what that unprofessional conduct is. We also have statutes and regs that refer to documentation and access also. But because of the nature of the complaint, where it came from, and it is a violation of the Health and Safety Code, we'd include it.
Yeah, the range seems arbitrary. I think that you have a good point of reducing the minimum so that you have a little bit more flexibility depending on what the facts of the case are.
So do you want to add public approval as a minimum, and what's in the minimum put as the maximum?
No, my recommendation would be to leave the maximum the way it is.
Just revocation?
Yeah.
Nothing else.
And then that leaves the option of a probationary order that's very consistent with 3 years and 5-day suspension and that kind of thing.
Any members opposed to that modification?
Okay, probation conditions, 55, page 55.
On 54, where it says CCNR section 1399.99.3, out of state should have a /out/of/state. And then the same thing for CCNR section 1399.99.4, out/of/state. Yeah.
$55. $56.
The top of 56, where it says if respondent is in default,
So your 56 is
yeah, it's probably a little off.
shifted.
It is,
What term numbers?
it's under cost recovery,
Uh-huh.
the second paragraph, and the second sentence begins, if respondent is in default.
Okay,
I didn't know if legally if you leave his, or if we try to word around it, if respondent is in default of the responsibility.
We had a very lengthy conversation about this while we were doing this.
I think there's a word around it, which is just to do the responsibility, or
Or
their
there,
responsibility.
yeah, there is pretty gender neutral.
And I think there's a couple of places, if you guys had a conversation about it, you probably know the other locations, but there's one in the
yeah.
4 right below it.
Mm-hmm. I'll do a global for is. 56. On 56, I had a note, if you wanted to change or, you took the words inside or out. This is on number 4, obey all laws. On the last sentence, I deleted whether it is inside or outside of California. It just sounds kind of odd.
Any jurisdiction with authority over respondent?
Yeah, we're already saying that if there's any, doesn't matter who it is.
Yeah.
Page 57. '58. 59. 60.
I have a question on my 60, which is number 16. At the end of it, the last new paragraph.
Maintenance of valid.
It's right above that. It starts in the event.
Okay, for tolling of probation.
Yeah, is this something, a new proposal, or does this exist and I don't know about it?
No, it's new, completely in underline. And it is feedback from staff and the probation monitor. When we have non-practice for 18 months or more, does it make sense to have them take the jurisprudence exam again with the idea that laws might have changed in their absence, if you will?
And they would have been doing continuing competency during this time,
Assuming that they've met all the conditions of their probation, yes.
which will include some laws and ethics.
Yes.
And the CLE doesn't change every 18 months,
No,
but their familiarity with it might.
might. And in the event that it did change, could.
There's a policy change, you guys, it's something to
Mhm.
think about.
Do we have examples, or is this hypothetical?
Nothing more than anecdotal. So, without delving into like specific cases, feedback from the probation monitor is that he feels that it would be helpful for those that have been out of state for whatever reason, whether it's, to avoid discipline or practice somewhere else, but then return to California more than 18 months later, that it would be consistent to have them reaffirm their understanding of the laws in California using the jurisprudence exam.
What's the cost associated with that exam?
I believe it's $89. Is it more than that? Oh, I thought you were shaking your head like I was wrong.
And it is when it says non-practice, would it be any kind of tolling then? Somebody could be tolling but be practicing somewhere else.
Correct.
So are you specifically saying non-practice or tolling?
We had a lengthy conversation about that topic as well. What we determined was that tolling occurs outside of the state of California and period of non-practice occurs inside for purposes of definitions. So we have had, well, you've heard examples of practitioners or licensees who find it difficult to find employment. And so they are, for the purposes of this conversation, non-practicing. Tolling when they leave the state of California. And that's based on research looking into the common definition of tolling with other boards' guidelines and those kind of things. So, but I think the idea remains the same regardless of whether it's tolling or non-practice. We're not going to count practice that they provide in another state as credit towards their probationary order here. And I think there's some consistency there as well, because they may be practicing under a practice act that is distinctly different than California's. And so with a period of greater than 18 months coming back to California, we may want to consider to have them test.
I'm wondering if there might be a different way around it because in, I believe at least all recent cases of discipline, stipulations and otherwise have included that the licensee take the law exam. And I'm wondering if potentially putting qualifier that the licensee take and pass the law exam within 3 months of returning to practice. And that way, you're not just getting it now, I mean, because doing it now, because they're being cited for violating, that if you put the condition on that it happens before they return, then you're ensuring that this issue is being addressed.
More current.
And so I'm wondering if that might be just another way around this, rather than having to put it into policy now, this way.
When was the last time our CLE was updated?
2012, effective 2013. It is just a concept, so, and it's based out of only one or two particular cases of concern, so it's not, you know, I leave it to
I see
higher
the,
pay grade to make that decision.
I see what you're going for here, or the probation monitor's suggestion, but I don't know if that's necessarily addressing the issue of tolling per se, because you want to make sure that they're practicing, not necessarily keeping up with the laws that are current, which our test is not even necessarily going to ensure that if it's an older test version.
Sure.
So I feel like if they're fulfilling their continuing competency, that is, if they're up to date on that, then whether or not they're practicing, at least they're current on the knowledge of how to practice versus a CLE that's out of date. Perhaps once we update the CLE, we can revisit this term, but I
Fair
don't think
enough.
it's necessary, personally, yeah.
We can strike it.
Any other board discussion on that? I'm interested in hearing how you guys feel about it.
I like my version with the adaptability, the flexibility that it gives, of being able to put the condition of when the law exam is
So-
done.
So currently what we have is they have to essentially pass the examination within 90 days, well, whatever parameter is set, of the effective date of the order. And they can work from the effective date of the order unless at that 90-day mark they have been unable to pass the California law exam, and then they're suspended until such time as they can pass. So I'm curious as to how we would determine when they left versus when they return. But, you know, one or two cases, and to Kat's point about the exam status currently, it's something that we could revisit later when we have a more real solution.
Comments?
I'm fine with striking it.
Strike it.
Right?
3 strikes, you're out.
Right, it is. 60?
On page 59, I just have three quick ones. In the third full paragraph, Business and Professions Code should include the word section. In tolling of probation, 16, on the second full paragraph, where it says notifying, the second I in that word should be deleted, along with vacation. And then in the last paragraph, it says, I'll just read the full thing. Respondent shall, comma, at all times while on probation, comma, maintain an active, and then it should include, comma, current license with the board, comma, to include, comma, including any period during which, and it should include the word their license is suspended or probation is tolled.
$60? $61? We have
Yeah.
a comment for discussion on number 21, practice or performance of PT while on probation.
Yeah, so through discussion with staff and legal counsel, for this particular condition, you might remember we've had respondents before us that have been disqualified from insurance contracts because of their probation. And thanks to former board member Carol Walsh, we did a little research into that to determine what kind of responsibility, if any, the board has or what kind of authority they can exert. And as I was reading this condition, I found maybe a potential for strengthening the language by eliminating the word sole. That the board may express as part of the disciplinary order that it is not the intent of the board that this decision and order, the fact that the respondent has been disciplined or that respondent is on probation shall be used as the basis for any third-party payer to remove respondent from any list of providers.
Can we do that?
You absolutely can.
I like it.
I like it too.
I think it goes into alignment with other language that's found within the disciplinary order that this board has determined that it is safe for this practitioner to practice under this order. I mean, they've already made the determination that they're safe for consumers. So I know that we've talked about how do we have any kind of influence over the insurance companies in a competitive market, but the only thing that I could find is by strengthening the board's intent.
I was wondering if it might be that after that first sentence, in that first paragraph or that first sentence, even something that kind of explains that it is the board's opinion that the terms of this probation provide a level of public protection. You know, I'm not sure if there's a way to say that other than it is not contrary to public interest.
Oh, I see what you're saying. So even strengthening that, and that might be a better effort, is just to strengthening the contrary to public interest condition.
Adequate level of
Public protection.
Mhm.
So there's some suggested language.
I think it's good to strengthen that part.
It is something like, it is the board's intent and belief that the terms of probation for, allow this respondent to practice or perform physical therapy with appropriate level of, I don't know, consumer protection in place, or I don't know, something like that.
Any suggestions, Tara? How to strengthen that?
Can you read that again?
Is that here?
I got most of it, but I'm missing like a little piece. I got, it is the board's intent and belief that, and I think this is where what I'm missing, the terms and conditions herein, we could do that, allow respondent something with an appropriate level of consumer protection, so
Provide.
Allows respondent to practice.
respondent to practice, okay.
How about something like public protections are not altered or diminished as a result of respondent being disciplined
bit
or
of an
placed
uphill
on
battle.
probation?
But we do,
Something like that?
I think what we want to relay to them is that the reason that we've even entered this is because we believe that these conditions provide a level of protection. Otherwise, they would be revoked.
Right.
Yeah, I mean, it's the spirit of this condition. And I'm wondering if it's, you have a very concise statement that is not contrary to the public interest for the respondent to practice or perform physical therapy under the probationary conditions specified in this order, this decision and order. But I don't know if there is a cause, if you will, to go past that, to extend past that language. I mean, you've made a determination through this order that letting them practice under the order is consistent with public protection.
I think what you're actually trying to get at is prohibiting the third-party payer from using the terms of the probation to cancel. So you guys need to
And I
say
don't-
that.
I don't so
think
much,
it's prohibiting them, I think it's trying to give them if there's a way that it would explain, I don't know, it's trying to give them the context that that as a group, it was decided that we really felt like this provided enough protection to allow this person to keep practicing.
the issue that we dealt with, trying to determine what causes them to be dropped from one particular insurance program to another, essentially boils down to that of competition and liability. But competition probably the strongest point. They have a number of practitioners that they can choose from, and when they are like qualified, this can be the deal breaker. And there's just something that we can't do about that.
And I don't even know if it's so much competition as it is that they've set standards as to who their policies are gonna, what kind of service they're gonna provide, and that includes their licensed people. So it may be something that you never affect, and it may not have to do with them
Yeah.
choosing somebody over somebody else, it's the product they're providing.
And that's the other side. I think that's the liability side of it. So those policies were created with that liability idea in mind, that that particular insurance company or that particular third-party payer isn't willing to lower their standards to that extent, for lack of a better term. Not necessarily stating that the quality of care is lowered, but that license being on probation is lesser than a license that's not. And they've set that in stone as a policy.
So, as it is, let me just clarify. So, when we say it's not contrary to the public interest, why don't we make it more affirmative and say it is within the public interest for respondent to practice? Because we say so we stated in the affirmative, like, oh yeah, it's within the public interest, we've determined that, and then we go into it, but at the same time, it's not the intent for the board to, have you been removed from a third-party list. Then we've explained the two sides of the story, that we feel we are still within protecting the public interest. So now, but we don't have really control over when the third-party payer decides that they.
But you've done just about everything you can at that point.
We've said, we've given you within our authority, we can say you can still practice. So we have trust in that you can practice, but at the same, and we didn't do this with the intent to have you be removed from a list.
So it's just a matter of changing the language from kind of a passive voice.
That's it.
But it is the board taking a little bit more of an affirmative stance. So again, that's to you as a group to determine if it's appropriate to state the board has determined that it is within the public interest for the rest of the language can remain.
Because we have.
It is the truth.
So I've got an idea
Okay.
to make this a little bit more proactive. Here it is. I'm feeling a little insecure about this one. This might be going a little too far. That's my disclaimer. This decision and order shall not be used as the basis for any third-party payer to remove respondent from any list of approved providers.
Can we do that?
Yeah.
Can we do that?
Well,
Jason's shaking his head.
because effectively, I mean, I think it's a good idea to research it. I'm throwing this out there because this is the board's decision. We're trying to send a clear message to third-party payers. And whether or not they find a statute that allows them to use a professional licensing board's disciplinary order against.
What if I only changed one word in your language and I was comfortable with that? So instead of the board or third-party payers shall not to should not. I have an issue with the board extending its jurisdiction over a party that it doesn't have jurisdiction of. And through our research, we determined a number of the people that dropped from those third-party payers, it was a violation of a contract that they had signed years ago. So those qualifiers were set in stone the minute they enrolled into that particular insurance plan or company. So the shall, I guess, is the issue where I'm kind of like, yeah, but to say should not be, it's a recommendation, it's a suggestion that the board is making.
Right, because the shall is like, if they do it, we still couldn't do anything about it. If they did drop somebody, we have no recourse.
It's true because we don't have any authority over the insurers.
I like the should not, though. I think it was very concise, the way you framed that.
So this would be in place of the second paragraph. And then potentially the first paragraph. We either go with Deborah's language, which is it's the board's intent and belief that the terms and conditions herein, again, I'm paraphrasing, allow respondent an appropriate level of, this is the problem with my writing. It is the board's intent and belief that the terms and conditions herein allow respondent to practice within an appropriate level of consumer protection. Or we go with TJ's idea, which is it is within the public interest for respondent to practice and or perform physical therapy under the probationary conditions specified in this decision and order.
That's a little bit too affirmative for me, because then if they violate, it's like we endorse them
You were
to
wrong.
continue to practice. Although I do like the positive spin on it. It's a little bit too much faith when we're still monitoring them for a reason.
The language has served us well for a number of years as it's written, with the exception of that, the one particular issue that we find with some probationers being eliminated. So it's, you know, we could leave the first paragraph as is, and instead of just removing sole basis, we could just change shall to should. Should not be used for any third party payer to remove respondent from any list of approved providers.
So going back to it's not the intent of the board.
Mm-hmm.
That whole, the way this is drafted right now, doesn't quite make sense. It is not the intent of the board that this decision in order, the fact that respondent has been disciplined or that respondent is on probation shall be used.
Should be used.
It is not the intent of the board that this decision should be used as the basis.
Should not be used. But not.
Should.
Oh, yeah, so you would eliminate not from the first sentence. It is the intent of the board that this decision in order, the fact that respondent has been disciplined or that respondent is on probation, should not be used as the basis for any third-party payer to remove respondent from any list or approved providers. It's very similar to what you've already stated. The not
Yeah.
is hidden in the first sentence currently.
I think my concern is just that it gets lost. The directive gets lost on the third line. So by the time I finally get to should not be used as the basis.
Tara, would you read your version again?
Yes, please.
This decision in order should not be used as the basis for any third-party payer to remove respondent from any list of approved providers.
I like it.
Where are we on paragraph 1?
I say leave it. Any thoughts?
Should we strengthen it by saying the board believes it is not contrary?
Has determined.
Or the board has determined it is not contrary?
I like that too.
I mean, I believe it's inferred, but I think that's clearer.
Yeah.
What are you thinking, Dr. Alviso?
I'm thinking that the second paragraph sounds too strong. But in the should not be the basis. Because the contracts pretty much say, if you're on probation, you're not gonna be a provider.
So this goes back to the original discussion that we had with senior staff and council with the removal of sole. So arguably, when they remove somebody as a result of them being on probation, there are actually two things they're removing them for. The fact that they're on probation and that they violated a contract that they agreed to get into the program.
Okay,
So we could add sole back in.
so it has to be violating the contract. If the contract didn't have it, then the person would have.
Which I think is
Which they
fair,
already have.
which I think is fair to the third-party providers. I mean, you might see change as a result from that, who knows? But you have an existing population of licensees, thousands of them, who have these kind of contract agreements in place.
Excuse me.
And for that matter, in some of the research that we did, the fact that they're on probation isn't why they were removed. The fact that they didn't notify the third-party payer that they were on probation was the taking point.
So those who notified them were not removed?
I mean, it's kind of an echelon of different variables where one insurance company just doesn't. They don't see it as a cause or grounds for kicking people out of the program, even though that it's in their contract that says that they have that right to do so. And then a few we found, the letter that they actually received saying that they were removed from the program was because they failed to report it, not because they were on probation. And so it's just a wide range of different reasons, and it's hard to address in a couple lines on a page, all the different areas.
I'm okay with whatever the group decides. I think the key is this is our statement of, you know, what our intent is, and whatever you guys are comfortable with. I can live with.
Straupel?
Just trouble. All right, so where should we start? Paragraph 1?
Yes.
If you are okay with the way paragraph 1 is currently written, perhaps, well, let's do that. Are you okay with the way paragraph 1 is currently written, please raise your hand. If you like paragraph 1 with Dr. Drummer's additions, which is the board,
With Mr. Kaiser's assistance.
with Mr. Kaiser's assistance, adding, it is not contrary, or what did you say to the board? The board has determined, the board has determined it is not contrary to public interest. I also like that one.
I think we're in agreement on that one.
Yeah. Okay, paragraph 2. You can vote twice, it's all right.
So you can vote more than once. That's a cool thing.
Paragraph 2, if you believe that Tara's version is appropriate, please, or sorry, if you believe the paragraph as written is fine, please raise your hand. If you believe the version that that Tara has drafted is appropriate, please raise your hand. And if you do not believe the way Tara has rewritten that paragraph, please raise your hand. One abstention. Okay, so we have the majority that feel that Tara's version is a good substitute for what's currently there. Would you like her to reread it out loud for you?
Or do you want to just
Okay.
give it to me later?
I'm going to reread it
Okay,
for
go ahead.
the record.
Thank you.
Thank
Go
you.
ahead.
You know, and hopefully the association will chime in on a 45-day notice if, or the insurers themselves, if this goes too far. You know, if we could get some public comment on this, that would be helpful. Okay, so strike the second paragraph of item 21 and insert this capital D decision and capital O order should not be used as the basis for any third dash party
Hold on, that's the basis, sorry. For any,
third dash party payor to remove respondent capital R from any list of approved
pay or to remove.
respondent
Mhm.
from any list of approved providers, period.
Anything else on page 61?
I have a recommendation for the first paragraph under probation monitoring costs,
Okay.
where it says, such costs shall be made payable to the Physical Therapy Board of California. I would recommend putting open quotes, Physical Therapy Board of California, closed quotes. And then it says, and sent directly to the Physical Therapy Board of California. I would change that one to just the board. And then failure to make ordered reimbursement, I would add the word "an," to make an ordered reimbursement.
Page 62. 63.
I have a question about 63, if that includes number 2, limited presence documentation review. Does that include that?
Mhm. That's on
62
page
as well.
62.
Okay, so at the end of that, it says once per shift, and then at the end says once per shift again, and I just wanted to know if that belongs there, because you're talking about observing the respondent and reviewing the documents.
Sorry, Deborah, where are you at again?
I'm on number 2,
Number 2,
The-
okay.
and it says physically observe the respondent at least once per shift, and may be required to review patient records and any pertinent documents necessary to determine respondent's compliance with this decision and order at least once per shift. When I first read it, I thought maybe you just wanted compliance once per shift. But then I thought, no, maybe you mean reviewing the records once.
Yeah, I didn't read it that way, but I see your point. It's not my intent to have them review documentation once per shift. I think that the way that the sentence is structured, about "and may be required to review patient records and any documents necessary to determine," allows for a range of flexibility.
Yeah.
I mean, and I think I'm more comfortable with that, and that the agreement between the respondent, the probation monitor, and the supervising physical therapist might have further detail out in, depending on the violations and those kind of things. So I would strike that second at least once per shift.
So it could end after decision and order?
Yeah.
And then I would remove the extra space there in the title, so limited presence / extra space documentation review.
$63. 64.
I have a question about, sorry, let me see what page I'm on, 64, number 3, so it's no presence documentation review is determined?
So for us, page 63.
Oh, it is?
The hard copy, 63.
Sorry.
That's okay.
This just struck me, in paragraph 3, where it starts each proposed supervisor,
Mhm.
so with this, could it be a private practice owner who's an employer be the supervisor here? Would that fit in this one?
It would.
Wouldn't you say that person has a financial relationship?
I do. I think there's a potential conflict there.
I never saw it that way till, as I was reading it.
And so I think what we've looked at in the past is the structure of that particular business, if they rely solely on this particular physical therapist, or there are other physical therapists in the practice, to determine how great of a conflict of interest that is. And so they still may be disqualified for the financial condition. But I don't recall ever having to do that.
And I see that, okay, now that you explain that, then it even has kind of the caveat of, that could reasonably be expected to compromise you.
Correct.
Got it, okay, I'm fine.
On page 62, the A for A and then space restriction of practice in the title there. A should not be struck through.
I'm sorry, where are you at?
At the top of page 62,
Mhm.
and then the heading with bullet A, and that bullet A is struck through for restriction of practice, that heading there.
Yeah, I don't show it that way.
I don't show a strike.
I see it online.
I do.
it online too.
Oh, wait. No, it is. Okay. It's hard
Yeah.
to see.
That's weird.
No, it's there. It's just in the same exact position as the.
Oh, I see it now. If I blow it up, I can see it.
Yeah. Okay.
This is my vision's going out. Saw it, didn't see it either.
Not on there.
She almost deleted this.
I have a comment on 63.
Or 63.
The paragraph, let's see, the last paragraph in 3, before you get to the letters,
Mhm.
it says within 14 days is the end of that paragraph. Do you need to put, you have to write out 14 and then put the numbers 14 in parentheses to be consistent with all the other numbers above that indicate time?
15? Within 15 business days?
14, it says
Within 14 is what it says.
You're saying should 14 be written out?
Yes, spelled out.
Do you
So-
have that written out?
We could do that as a global change, that any time that we have numbers in parens that you'd want it spelled out in advance, okay.
Oh, I see what you're looking
Because it occurs in other areas also.
Mhm.
Okay, 64.
third paragraph under F, right above item B. It says consider a modification, only there's too many Fs. So perhaps delete modify and insert modification.
Where is that?
Right above B.
Oh, modification.
Modification.
at.
65.
Sorry. The big letter B, practice monitor required.
Uh-huh.
If you were applying this one, would you also add A in the order in case their status changed?
That's
So
the
it goes
idea.
in it, it goes with it.
Yeah, so that's the kind of issue that we ran into a few years back, where probationer decided to close their practice and go work for someone else, and created a conflict, bringing the practice monitor along with them, when really the more appropriate thing to have done is have the language in the order be able to adapt. And so we would include A.
So I'm wondering if that note at the beginning of that, instead of it saying this condition should never be used with condition A, I'm wondering if it should say, kind of like condition A should be ordered in this probationary order in case the person has a change of employment.
Yeah, I think-
However, A and B would not both be active terms or something like that.
I think with our addition, the following conditions shall only apply. We actually forgot to strike never be used with condition A. And so that recommendation of the insertion is a replacement of what we forgot to strike for presentation's sake.
So I'm good.
But to go one further, you could say used in conjunction with.
A and B should both be ordered.
Yep.
If some level of, so I don't know how to word that.
This condition should be used in conjunction with condition A.
But not used in conjunction with it. It should be included in the order.
Mm-hmm.
Hmm.
but only,
So that's what's lost, right? So we think we covered it with our insertions of when the conditions should be used, with the purpose that we know we're going to include both, when and if they're appropriate. But it loses translation here, especially for an ALJ.
I think if someone, is a standard term prohibition of ownership?
Yes,
So if somebody was under A, they're not gonna be in a position of B.
right,
But
so
if
it's
they're,
very
if
rarely.
you're ordering B, you should order A.
Right, very rarely
Also.
does it work the other direction. We're only really taking a private practice person who we've determined is appropriate to keep their practice. We're building in that safety net that should they choose to close their practice, they're covered under A.
So the suggestion to the ALJ would be that if you're ordering B, you should include A to provide proper flexibility.
Yeah, and that could be done in that new insertion.
Okay.
But A and B could never apply simultaneously.
They could, because
Well,
that's
they
the
have
other,
different settings.
right, and that's why we wrote it that way, but, well, it has, it's happened, so a practice monitor who picks up shifts on the weekend at a local practice falls under two different categories at that point, and makes it very difficult for us to impose the practice monitor over this practice he's picking up shifts on, so, or doing per diem work for. But I think we can address that by keeping the two insertions on both A and B, but on B, adding the language that says, condition A should be used to provide for to provide for flexibility in employment.
So when I look at B, that says this condition should never be used with condition A.
Right.
I know we're changing that. It's similar to what's under A. This condition should never be used in conjunction with B. A, on the other hand, seems to really attempt to describe the situations that A would be used in lieu of B. Is it possible to keep this language under note A and then just refer back to that language under B?
I think in composition of the guidelines previous, we felt it necessary to say that the two should never be used in conjunction with each other, so we made it very concise and specific and stated it in each condition. And we found over time that there are combinations that can still provide consumer protection and be allowed. We know that restriction of practice A applies to a PT who practices with or under an employer, has no interest in the practice. But a standard condition is no ownership. But I think you can imagine instances where we might allow them to work under A and still maybe consider opening their own practice at some time during the probation. I don't know what that imagining entails, but allows for that flexibility. So striking the nevers from both and then making the clarification that when B is used, A should also be used, I think covers all the bases.
Okay.
So on A, the last sentence of paragraph, titled note, we would strike this condition should never be used in conjunction with B.
After reading the note under A, I think it kind of clears everything up for me. don't know if anyone else feels that way, but if you read A, it says when you would use that instead of B. So I'm not sure that we need to restate it under B. And both of them say you only use one, you don't use both.
I guess the concern I have is that when it goes before an ALJ for a proposed decision, that he only addresses the current situation, that the person has a private practice, so they only apply B. And I want to make a note there that anchors that thought that you should write this order to be adaptive to that person's situation. So if they choose to close their practice and go work for someone else, that A would be there to kick in. So that the supervising PT would still be required, but now they wouldn't have to bring in a practice monitor who they're paying, and is also a third party coming into this new practice that they're attaining employment at.
I think the tricky part about including the application of A later, let's say the person is self-employed and they're gonna allow that to continue, but at some point the person decides to close their practice and now A is going to apply, is now the determining the level of supervision hasn't really been done. Which level of A hasn't really been done because it wasn't applicable at the time that the order was written. So is that gonna all be done by probation monitor?
I think you can do it in advance as a decision by the board too. So I may make a proposal and stipulation that currently the situation is B, but should he close his practice and go to a place of employment, that I would recommend A level 2, something like that, to which you might modify it or change it, or in stipulation write something in language that says to be determined by the board or its designee, and then you would be putting that authority over to the probation monitor.
So would we ever be applying B and not want A as a backup?
I wouldn't recommend it.
So should B just include that? Should its term just almost have it as a default or a?
So in conjunction with A, if the respondent owns his own practice, apply B.
No, that's not what I was thinking. I was thinking in B, near the bottom, it would just include the term that if the person has any type of practice that is not a shareholder, a sole proprietor, all that stuff, then probation term A would be implemented or something like that.
I'm wondering if we could just change the term shall apply to shall be operative.
That might.
Because apply, to me, that's an instruction. If I'm the ALJ, this applies in this case. Oh, it doesn't apply in this case. When I get to B, then I get confused. But if I'm an ALJ, I'm thinking, okay, this would be operative in this situation. So I go ahead and just add A, provide for that, and then I get to B. And I see, oh, this is only operative in these cases. I go ahead and add B as well. So it's not that whether or not it's applicable or not to the case or the situation, we're trying to get at a fact not currently before us, which is what vested interest someone may or may not hold in the future.
I think shall be operative is a valuable addition. I still think that there's something that needs to be stated for an administrative law judge to follow to include A. And it has to be with that idea to allow for flexibility of employment. So with some explanation. So should respondent choose to close a practice that he has a vested interest in, A shall apply. at this level.
I could go for that.
Yeah, that really captures it, the addition of operative and redirecting them to A. I think it's good. Any other thoughts?
Where would you place that in the body of B?
In the additional note that we've, as an addition,
Yep.
Did you need that repeated, Elsa, for the record?
Just a second. So in A, we're gonna take out apply and put shall be operative, right? You want operative?
Right, so apply is a strike through,
Mhm.
insert B operative.
Mhm. And that's the only change in A. And then B, you're gonna do the same thing. Strike out apply, put B operative. And then within that same note is where you're gonna put this condition should be used in conjunction with A.
to allow, and so that's the part where, to address Tara's concern, is that you're trying to predict for something in the future, and in the guideline, this option should be used in conjunction with A to allow for flexibility in employment if respondent should close, and we'll have to kind of iron that language out a little bit, but practice under condition A, the following level should apply. Some guidance there that does tell him to determine one of the three levels under A at that time. And that's tricky. I'm conflicted on that one because when we've determined that that person's safe enough to keep their practice and have a practice monitor, it's really documentation review, and to the extent that we write it into the order, observation on a frequent basis kind of thing by a practice monitor, it's essentially A, C. You know, no presence required, documentation review. So we could specify it as when they leave or close their place of business, wherever they go, they should be required to have a supervising physical, I mean, just take the language from AC and put it into B. But it limits the flexibility a little bit of the board. And some of the flexibility could be applied outside of the guideline too, given circumstances and variables. So we have the guidelines as they're written now, and they're very effective, but every once in a while we stray outside of them because of that particular person's circumstances, and we could continue to do so.
I have another note to the beginning of B, under the note. I think the sentence, the beginning sentence should probably change to strike be applied, because again, it's this weird, confusing instruction. Well, I'm wondering if it should instead read, this probation condition shall only apply at such time, paren S and paren when respondent holds a vested interest. So, because this is a note, an informal note, we're trying to say there's only certain times maybe that this will apply, and it's when there's a vested interest in a property or a practice. I'm not sure if, I mean, we could tweak that language, but I think we do need to change shall only be applied because it, you know, we get back to the same problem.
It's great.
Yeah, it is cleaner.
So also the proposed language, if we're all in agreement, is this probation condition shall only strike be applied.
Strike be applied.
Yeah, insert, apply at such time, paren s, and paren when.
At such time, sorry.
When shall only apply at such time when. Strike if, unstrike the. Unstrike, is that a word?
It is now.
Making it up now.
De-strike.
So it'll read, this probation condition shall only apply at such time when the respondent holds.
Okay. And everything else stays.
Looks good to me.
I'm good.
Okay.
$65.
Can I make a comment on 62 under 1, where it says full presence documentation review? And then the sentence right now reads, the level of supervision shall be direct and require the physical presence of the supervising physical therapist while physical therapy is performed by respondent, semicolon, may require the supervisor review. I'd add the word to review and then remove the word of to review patient records. And then in the sentence that starts direct supervision and physical presence means, and then it has a comma, I would remove that comma.
$65. $66.
Well, back to 65. So there is another point of addition of a new idea, and that is whether or not the board would want to restrict a licensee's ability to utilize direct access.
Yes, that. Do we already have that flexibility in some of the, in the 2 restriction of practice of either the type of person? Maybe the population?
The demographic restriction?
Mm-hmm.
I'm thinking the restriction of practice, prohibition of treating a specific patient population. That could be those under direct access. If you thought it needed to be specific,
I don't. To go one step further, we also have a prohibition of performing certain types of modalities. So I think I could fit it in either of those 2. I don't know it's necessary anymore. And really, we don't really have a fight in this one. It was just a suggestion that we took from staff. It's something that we would want to float, by you as a group to see how you felt about it.
It's an interesting concept.
And I say that because I don't even have an example of when or how I would apply that from experience in past cases or even trying to imagine cases moving forward. Except for somebody who may have utilized direct access inappropriately
Right.
Mm-hmm.
on a repetitive basis with numerous acts and that kind of thing. But I think I could fit that into
Definitely.
patient population.
Yeah, because I think possibly we could have a probationer who's in a setting where a portion of the clients are direct access and, those are still patients that they would, the monitor would still want to supervise them with, so.
Well, if you think you have what you need by incorporating that in the other term, then I'd say we could strike it.
I would recommend adding a note, so that, because, this is one of those instances where anyone could look at a specific patient population under item H and not understand that, oh, wow, we could add 2620.1. So I think there would probably be really helpful to provide some examples of specific patient populations, which could include direct access.
I agree.
We don't provide any kind of note as to what patient populations are provided for now.
That's term H. It just says respondent shall not treat any blank.
I like the idea of it as a term, only because it is one of the, I don't know, the liberties are right, but it's one of the newest areas. And so the ability to restrict that is kind of interesting thought. But I think I also could see that occasionally we might get a decision that would include this for some reason. There was an option and they saw it. And they
Inadvertently.
And then it's maybe one thing that we wouldn't have included. So I could see it inadvertently hurting the
Misused,
decision
yeah.
or from our standpoint.
So maybe a note under H to list potential populations that could be excluded. I think that was your point, right, Tara? To give them some ideas that.
Right, to specifically call it out there that that's where direct access would be excluded.
As one example.
Right.
So in the next condition, it's the prohibition from performing specified physical therapy procedures. And the language, while it doesn't quite fit, actually fits the situation a little bit better. And I think it's clearer, if we were going to use it at some time in the future, that during probation, respondent is prohibited from performing or supervising the performance of direct access services, so on and so forth, or
Yes.
it even allows for until respondent can demonstrate competency in performing direct access services. So I don't know that any change is necessary. I think I wasn't imaginative enough in the first place.
So is the board okay with striking the new term that would have been D? Prohibition of direct access?
Yes.
Okay.
So on 66, add a note in brackets. I don't know if there are any additional, what other types of populations. You guys,
Male
I've
or
seen-
female or geriatric or pediatric or,
okay. So perhaps it's just note examples of specific patient populations include children, comma, female or women, comma,
Or
Direct
specific-
access
specific
clients.
gender.
okay, yep, right, specific gender. I'm just doing this so that they can get the rulemaking going, and there's at least language in there that could be tweaked later as necessary. However, on 67I, I'm a little concerned about including specific direct access patients under physical therapy procedures.
yeah, no, it's the more the language than the condition itself that I was seeing the value in.
Okay.
So in a, maybe in a stipulation, I take language very similar from I and use it in condition H,
Okay.
where it's still patient population, but it's specific to direct access.
Okay. I'm just saying that I think adding direct access services to I might be problematic.
It is,
Right.
Okay.
it is.
68?
On 66, what's currently heading G, restriction of practice, I'd add a hyphen or dash between third party.
Are you at letter K?
68?
61.
J at the top of the page.
Okay. K. The second sentence, so the second time you see respondent,
Mhm.
it looks to me like that sentence and the next one should move down to the very bottom of that section. And so it's that the respondent shouldn't supervise before seeking the,
Yes, which
during the period of probation,
Switching the
unless
two
they
sentences.
first obtained board approval. Then the next thing would be, after so many years of compliance, they may remove the restriction. Then it goes back up, if we picked up then with the second sentence, it would explain then how their supervision's gonna happen. Sorry, I'm gonna change that. My proposal is that you have the first sentence,
Mhm.
then it goes to the last sentence of that paragraph, where they have to terminate any supervisory relationships they have.
So make that number 2,
I think so.
okay?
Then your second paragraph, that explains they may be authorized. And then back up for the second and third sentences, I think.
flows much better. It's like step one, do this, step two.
Yep.
And you would apply that sequence to L as well.
I think the tricky part is to make sure that it gets called out in the decisions, that there's a little variable in there whereas it kind of stands out right now because it's the second paragraph.
So for the second paragraph, that could also be labeled as optional language.
After X years?
Yeah, so, and that's to the board's determination. Would you want to offer that to each and every person as part of the guideline, or would you want to clearly delineate now that that's optional language?
And if that's optional, then maybe that second and third sentences that I keep looking at,
Yeah,
maybe those belong with the optional language. Because they talk about being able to supervise and what that's gonna look like
mm-hmm,
and the conditions of it. Maybe the real term is just they shall not supervise and they have to terminate any that exist. Everything else becomes the optional part.
so there's a greater change that's being presented here, though, where we're saying that they shall not supervise any assistive, I mean, if we're taking K and L, it's kind of a combination. They shall not supervise any assistive personnel without the previous approval of the board's monitor. So we would have a list of every assistive personnel, who they are, gives us an opportunity to determine that they have competencies created for all, and an option to interview them as part of the probationary period. It's different than what we do today. In certain circumstances today, we just restrict them from being able to have assistive personnel at all.
Okay, so hang on. Now you just made it bigger, right?
Yeah,
Because now, I know that sometimes the probation monitor has made it clear that sometimes it's important for him to have the shall not,
mm-hmm,
is not allowed. And so that's now missing from these two. Because you just called my attention to it, which is unless it's first obtained. I think it's still important for us to have
absolutely.
a probation term that is absolutely clear, no discretion, no aids, no assistance. And then optionals to that would be different.
So the underline that we have now that we're changing the sequence is optional in its entirety.
Now I see that, I didn't see that before.
I didn't either.
Although I guess I was reading it
Yeah.
from the standpoint of, unless they have that board approval. And I thought that board
Right.
approval was after so many years of compliance or whatever that was down below.
Yeah, and if you see the comment that Elsa makes in the column, it's considering leaving the strikeout language so that we do have that range where we do absolutely and could and necessarily restrict them completely.
You could designate this with the returning the stricken language, and then below that, putting or in capital letters, and then providing,
The third one.
Mm-hmm.
right.
I have a question. So there've been times recently where we're moving toward allowing them at some point to, are we putting that in the initial order?
Yes. As optional language for those particular cases.
Are there some cases where we would never consider this, that we would?
Yes.
Okay, okay.
I very much could see where I could not in good consciousness make a recommendation that they have assistive personnel.
For the entirety of their probation, for 5 years?
I think I could see it, but I've expressed to this board the kind of cold turkey methodology of taking it away from them for the whole duration and never seeing or witnessing or having an opportunity to remediate. So even in a 5-year, my hesitation is to do the last year with. 4 years off, 1 year on.
So you can monitor them with,
Yeah.
right?
Otherwise, I have this kind of a missing element, if you will, that I have no insight as to what their supervision looks like before I release them back full-fledged, and they can supervise anything or anyone, actually.
Well, it seems as though there's 3 scenarios, or probably 4.
Or,
One where we don't, the order that we're gonna have is none, not allowed. And the second one is what you intended here, which is there might be a review and approval of certain people.
mhm.
Okay. Then there's, after a certain period of time, we might be able to modify it or remove it. And then there's the, after 4 years, we are gonna remove it. I mean, you know what I mean? It's
Yeah.
almost like you have all these,
I think by the operation of the language we've had in the past, that 4th one becomes obsolete with the previous 3. Now that my concern is, I want some insight into that, what that supervision looks like during the probationary period. Using 1 through 3 accounts for that in 3. 4 becomes unnecessary. But I can see definitively why I would want respondents shall not supervise through the duration of the probation. So unstriking that language, creating an or that has this new language, but with the sequence that you provide, and then as optional language, after a certain amount of years, either term could be modified.
have we had people come petitioning for this term to be modified?
Yes. And that's part of where it's driven, is from feedback from respondents, but also the concern about their supervision and the cold turkey kind of idea. But you have had petitioners come here asking if they can supervise assistive personnel. It expands their opportunity for employment.
So with this proposed language, are we prepared to allow ALJs to utilize this and try to come up with something that this board, the people at this dais might have better insight into, and to be able to allow us the leeway to make these decisions versus somebody who has no significant connection to practice?
I think you find that difficulty or that frustration with the entirety of the guidelines at that point, to a certain extent. We have had to, as a board, not adopt ALJ decisions for a number of different reasons, because the guidelines weren't followed at all, or they were followed inconsistently, or they were henpecked and, kind of chosen without much explanation. So I don't think this alleviates that problem at all. But I also don't think that it really exacerbates it either.
Well, I do like to unstrike the initial language and to have the or with the restructuring of the paragraph, the way Dr. Alviso described it.
And then the optional language below, with that last paragraph after X amount of years.
That paragraph was moved up, right?
I think I would like to, I'm kind of thinking what you're thinking, and Dr. Drummer, in the sense that if we recall that this is really direction to an ALJ about this board, I think what I would want is that it's really clear that the starting point for these is the restriction. That's really where these terms started and what they're about. The exceptions are exactly that. They need to have just the right conditions that these are being considered. But the term is the no supervision. So however we can make it look that way, and I'm guessing we'll probably need to see this again, but I think I'd be really comfortable with that.
So in unstriking it, we go back to the previous state of the language where it is just definitive, no supervision. And maybe it's not or, maybe it's optional.
To clarify it, or to qualify it as optional language, or that there is some,
If you're going to exercise a point of discretion, please do it this way.
exactly.
And I will tell you that in conversations with the probation monitor, the reason that we came up with this language, it kind of fell into our laps a little bit. So it was presented as an alternative by Respondents' Counsel. And in reading it, we thought, it's kind of genius, because it really allows the board control over what that supervision looks like. The board is going to, one, be able to verify that the assistants and the aides that are being utilized fall within the regulatory guidelines, that we have competencies on file for them, that they're properly trained, that the documentation's being done correctly, that they don't have discipline on their record if they're an assistant, and those kind of things. So we saw the value in the language and plagiarized it a little bit, if you will.
So with this conversation, I'm wondering if we should strike no from no supervision, because potentially we're talking about supervision of PTAs and PT aides.
Well, it is a good place to start.
Don't make me go level A, B, and C, like,
Yeah, I was thinking about that.
I think it might be interesting to consider still having a no supervision term and then having a limited supervision term.
An addition of a new term. I like it,
I do too. Just separate them out.
for both.
Yeah, for both.
No.
Is that confusing? I mean, do we need to then say, again, conditional use, don't use A if
Right.
B is in there? Because they could actually include both, yeah, if they're not reading. Because we're also talking about DAGs and the stipulated settlements, and they're many times copying and pasting.
I think it might be interesting to go through, back up to the beginning of the disciplinary guidelines and see if we would by violation apply one or the other more strongly. If you would do a limited or a no, if you could do that by the violation.
Do you want to go back to page 1?
Yeah.
We could just start all
Not
over.
today. Because you're right, if we just had K and L, because one is limited and one's full, maybe it wouldn't help at all.
Mhm.
K or L, maybe that's what you do.
K or L.
K1,
Yeah, I
K1
mean,
and
that's-
K2.
That's what I would propose in the rest of the document for violation specific, is that we would list both so that discretion could be applied. But I do think that maybe over time, and just through the collection of data, that we could determine one's not appropriate for a particular violation and this one is. But I think that's kind of for the processes of what we're doing now, including both, is a better way to do it.
And maybe K1 and K2.
So, currently, restriction of practice, no supervision of physical therapist assistance would be K, with optional language of after so-and-so years. And then the new L would be restriction of supervision, well, limited supervision. It's not limited. What's the word there? Supervision of physical therapist
Supervised
assistance.
supervision.
Just no. And then the new language.
Yeah.
would apply that to L as well. So L would become the new M, and the second version of that would become the new N.
So we wouldn't do K and option 1, option 2?
And I'd leave that to smarter minds than I. I think if you use different letters, you can use Tara's language that says, you know, K and the new L should never be used in conjunction with each other.
Mm-hmm.
I think if we're going to have a title that says supervision, I think you should just put both conditions under the same and either have it no supervision or modified supervision.
I agree with that as well, because if you did want to move from no supervision to limited, but you put in the note, you can't combine these two terms, then you're like boxing yourself in, are you not? If you said absolutely no supervision, letter K, and under L it said you can't use L and K together, then where would that give you the opportunity to monitor them the last year of probation?
So I'm in favor of K, restriction of practice, supervision of physical therapist assistance. 1, no supervision, and then describing terms. 2 would be the optional capacity for flexibility. And then L, restriction of practice, supervision of physical therapy aids, with 1 and 2 the same. In my mind, that keeps the target of supervision within a boundary of the letter, and then there's the options that fall below it, rather than creating separate letters, which we have too many letters. We're already into double lettering already.
And it also addresses Tara's concern of being interchangeable and used inappropriately.
Right.
But it doesn't address Deborah's comment for the third scenario where the respondent doesn't have the onus to come back to us and ask if they can supervise, aides or assistants, but we actually feel like that's something they might be able to do up front.
That could be done. That could be an option.
So if you look at the alternative, what we're calling the optional language, it says the board or its designee may remove the restriction or authorize limited you have that control that's very similar to the previous paragraph. So Monty at that point, as the probation monitor, would be able to say in that if it was appropriate, and he deemed it to be appropriate, he could say, I'm going to allow you to supervise, but I'm gonna need you to provide me a list of everybody you intend to supervise.
So that last paragraph is separate from the second paragraph.
Yeah, it could be used with the strike language or used with the new proposed language.
Got it.
So K is K1, K2, optional language. L is L1, L2, optional language.
I agree. How's the rest of the board feeling about that? It's not.
I'm afraid to do this.
Oh,
Anytime you start a sentence like that.
Yeah. But I'm asking, how many of the cases that we see, do we actually say, no supervision at all? This is the way it sits currently. Are we solving the fundamental problem?
mm-hmm.
If we are, and we wanna, accommodate that other 20% or 5%, do we really wanna not make it ambiguous, but adding another limited language to it? Because AOLs, they are going, the judges are going to make those determination, and it may not be as clear for them as it is for us to make that determination. And will it eventually come back to us and we will say, oh, no supervision?
Absolutely it might. And you run into those situations now with the way the guidelines are written currently.
Right.
It is reasonable to expect the ALJs to become more familiar with your guidelines as they work with them, but it's unreasonable for us to expect them to have the same understanding, intent, and purpose that board members do.
I'm glad that TJ's bringing this up, because I really am, because the way that it's presented right now without any changes under K is it's saying you can't supervise. There is no supervision, but you can come back and ask, or our designee can
Make
suggest it,
determination
yeah.
to now ask.
And so, I don't know, maybe, I know Deborah, you had mentioned that, you know, you want to make it clear that they can't supervise, but the way that I read this is, it does say you cannot supervise. And if you want to, you can come back and ask, or our designee can suggest it or what have you, but.
And you're absolutely correct, but because the way that the first sentence is structured, it runs it all together.
Yes.
It doesn't have the definitive statement, no supervision. You can't supervise. Potentially down the road, or potentially with board approval, then you would be able to supervise.
Which,
Instead of having it be separate constrained sentences, which would seem to, in your mind and others' minds, to be more definitive.
which first sentence are you referring to? The first sentence
The
stricken?
addition,
The
under
addition?
the pink strikeout. So respondent shall not supervise any PT assistants during the entire period of probation
Period.
unless he or she has first obtained board approval. Blah, blah, blah.
Mhm.
So, because the sentence has the constraint, but then it also
Allows.
is open, it loses the impact of the constraint. Because, right away, I'm allowing you to, oh, but maybe we can do this. Maybe we can work out a deal instead.
Even with keeping K1, which is the stricken language,
No, keeping the stricken language to me does that.
okay,
Right. I think Alicia's looking at that going away, and so that first sentence never really has the constraint placed, which is, no, you don't get to. But then, in my mind, you open a second sentence where you describe what the options are. And if we were going to keep one as what we essentially have,
Mhm.
or some variation of it, and then two, this new sentence.
I'm sorry.
Yeah.
I guess that was my understanding, is that K1 is the stricken language.
No.
Yeah.
Well, yes, yeah,
That's what I thought.
yeah.
That's where we'll go.
So that would be the absolute no supervision of any kind. And then an optional, if appropriate, of after certain years of full compliance with probation, the board or its designee may remove the restriction or authorize limited supervision of physical therapist assistance. And in those scenarios, I'm envisioning a 4-year probation, 5-year probation, 3 years with absolutely none. And then should Monty or the board's designee at the time determine that it's appropriate, allow it, and allow it with certain conditions. That's one. One with optional, because without it, for the full duration of the probation, they'd have no authority to supervise. And then two would be this, the language that's underlined as added, resequenced with what we've discussed before, and also having the ability to use the after such and such years.
It'll automatically just kick in.
Well, you, at the time of you proposing a decision, the ALJ proposing a decision, me negotiating a stipulation, determine whether it's appropriate or not. To get rid of it altogether, or to further modify it, or remove more restrictions as appropriate. based on the board's designee's opinion. So I think K1 and K2 with the optional covers all of what we're trying to achieve. And yes, I think any time that you provide these guidelines to an ALJ, they may not be used exactly the way the board would use them.
I've got one comment on this optional language. I think the full optional language really only applies to K1 because K2, that's already your modified, right? So really the only optional language for K2 would be,
Remove.
yeah, remove entirely at the board's or its designee's approval. So if we were talking about K1 full option, K2 removal option only.
So K1 and K2 should really have their own options separately.
Right.
I like it. How's the board feeling? Like it's after 5?
Worried that 8 o'clock is gonna come.
Before you know it.
You guys are doing really good.
Oh, thank you, Jason.
That's what got us to 8 o'clock.
Do I have any objections to the K1 optional, K2 optional scenario?
So just for clarity's sake, K2 optional would read, after such and such years of full compliance with probation, the board or its designee may remove this restriction.
Correct.
That's K2.
Correct.
K2 option. Hearing no objections.
Wait. That's K2? Because that gets rid of the other one that you were saying, which is approved people.
Mhm.
To be clear, K1 is no supervision, period, which may be revised at a later date
Yes.
to provide for a limited supervision or remove the restriction entirely. K2, approved individuals with the option of removing that restriction entirely. Is that clear?
Yeah.
Okay.
I thought you were saying that, okay, that's good.
So K1 has its own option and K2 has its own option. Because K1 is more restrictive, K2 is less restrictive.
And I'm okay with that from a practical sense, because really you've, at that point, determined the probation monitor is going to state what's appropriate, what's not. And so if he wants to, for the ones that have that limited supervision role, make changes, he has that authority to do so anyway. To get rid of it altogether is kind of an added authority that would only be applied in cases that it was appropriate.
Okay, so that same structure will be in L.
Mhm.
So. 69.
Yeah, let's take a 10-minute
you're out of
break.
practice.
We will reconvene at 5:52 p.m. 5:53.
Is that 5 minutes?
That's 10. All right. We are back on the record. The time is 5:52 p.m. I believe since we still have a considerable amount left to cover this evening, that we should recess until tomorrow morning at 9 a.m. and pick back up with this agenda item then.
In that order, because we might be conflicting with.
After the presentations from the outside stakeholders. Yes.
Aye.
Aye.
So there was no motion, but we have votes. All right, we'll see you guys tomorrow at 9.
Good job, team.
Yeah, go team.
Just as I started my.
You're just about to break into those donuts, huh?
You're getting comfortable?
Let's get you comfortable.